All right, we're live.
Hi, everybody. Good morning, good evening. Welcome. This is Tanya Friedman. I'm the Chief Operating Officer of Kinetics, and I want to welcome everybody today to our very first Facebook Live session with 3 of the top immigration lawyers in the US. So I want to welcome Carl Schusterman, Chris Masello, and Jacob Sapochnick. Welcome, everybody.
Thanks.
Today's session, so today's been a very busy day. We just had a Facebook Live session for the IELTS, a free class for IELTS. So those of you who haven't watched that one, if you still need to pass the IELTS, please watch that Facebook Live session. But double excitement today because we're having the immigration session as well. So last night, Jacob and I did a little preview just to test the technology and make sure everything was working. And in about, Jacob, I think it was about like 3-4 minutes, we had a few thousand, almost like 2,000 people already watching, right?
Yeah, so I think by the 5 minutes, we had like almost 1,000 views.
Yeah.
Yeah. And so, we already have about 25 people on right now, and they're keeping, I think. Yeah.
Okay, sounds good. So I know we had a lot of people that posted into the chat box that they would be attending. So I'm sure that our numbers are going to grow. And for those of you who are not able to watch this live, or you know, if you're sharing this with your colleagues or your friends, please know that it will be recorded, so you will be able to watch it afterwards. So just a little bit of background before we get started. As I said, I'm the Chief Operating Officer of Kinetics. We specialize in the direct hire recruitment of nurses in all 50 states. We have clients, acute care hospitals, nursing homes, surgery centers, rehab, correctionals, really in all 50 states. And I am, as you can hear, I have an accent. I was an immigrant myself many years ago. I came to the US almost 20 years ago. And it has really been a passion of mine to be able to make sure that people get the accurate information. Immigration to the US can be a very stressful process. I know personally how hard that is. And I think today's session is going to be so helpful and is going to be of service to so many people. So today we have some set questions, and then we also have questions from people who have posted into the chat box previously. And I encourage all of you, please, to add in your questions so that we can ask the panel of experts. So I'm going to just read off Louise. So shout out to Louise and the Lafora team for allowing us to do this. We're very excited and very grateful for their support, because we know that this is going to, you know, they know this is going to be of service to so many people. So I'm going to just write out just a few highlights of the very esteemed panel. So I'm going to start with Carl. So Carl has 40 years of service practicing immigration law. He's certified immigration naturalization law by the California State Board. For 10 years, he's been voted as one of the best lawyers in America and as a super lawyer by his colleagues at the bar. He was featured in February 2018 issue of Super Lawyer magazine. He's one of the top 15 corporate immigration lawyers in the US by Human Resources Executive magazine. He had the highest rating in legal ability and ethics from the prestigious Martindale Hubbell Legal Directly, and he is in the international who's who of corporate immigration lawyers. Wow, Carl. So that's about Carl. Then I'm going to talk about Chris. So just a little bit about Chris. Chris is the managing partner of Marcella Unkenholt, and he's actually a moderator of Lafora. So Chris knows Lafora very well and has helped a lot of people in the forum already. He graduated at the University of Cincinnati College of Law in 1998, specializes in healthcare. Chris and I have actually worked together for many, many years, as have Carl and I, and Jacob as well. And his client base is wide-ranging, including the largest healthcare companies in the US. He's been featured in the American Immigration Lawyers Association annual publications. Cincinnati Bar Association report, selected as a speaker on many national and international conferences, and he has been successfully involved in the American Association of International Healthcare Recruitment since 2008. So been involved in healthcare and nurse recruitment for many, many years. Third, but last but not least, is Jacob, who is the managing attorney of Law Offices of Jacob Sapochnick, an active member of the American Immigration Lawyers Association. He's a founder of Find Jobs USA, one of the first job search sites focused on international workers seeking employment in the US. He's been quoted and featured on numerous newspapers, TV outlets worldwide, including CNN Money, ESPN, NBC News, ABC, Fox, ABBA Journal, CPBS, just to name a few. He's written articles for various publications in North America. His firm is a pioneer in social media engagement in the legal world, and their Facebook page is one of the largest in the world for any law firm. And he graduated from Manchester Metropolitan University and attended California Western School of Law in San Diego. So we have the real deal, the A-team of lawyers here, everybody. This is extremely exciting. Before we get started on the questions, just a few things to note. Everybody will have a chance to answer their questions, so please make sure to put into the chat box any of the questions that you have. We do have some set questions, but we really want to make sure that this is participative. So everybody who is in the session right now, please put into the chat box how excited you are. Please say, I am excited. And please also add in, I am going to share this Facebook Live session.
Excellent.
We
only have 100 viewers, less than 5 minutes.
Okay, and good.
I wanted to maybe say a few words, and then you can start the panel. You know, yesterday when we did this little experience to test it, we were getting some comments from people that were really frustrated with this whole system. And I know you guys will feel the same. I don't know. I've been practicing less than both of you, but I feel that I've never seen so many denials and RFEs and I-140s ever for nurses with very, very difficult requests for evidence, almost kind of, I would say, even mean, to simplify it. I feel so many frustration in this industry right now because of what's happening from the government. So I just want to say that we are aware of that. We are dealing with it. We are adjusting our practices accordingly. And maybe as we go through the answers, each one of us can give some examples of what we're doing to tackle those things, how we are fighting the RFEs, and what are we doing to help our nurses and our hospitals to adjust to this new era. And I believe it's a new era. Maybe just me, but you tell me if I'm wrong.
No, I think that's a good observation, Jacob. We have seen, and I'm sure Carl would agree as well, over the last year or two, and not just for nursing, but for all sorts of immigration processes, really some of the highest rates of RFEs and denials that I've seen in 20 plus years of doing this. That's the bad news. The good news is the demand for nurses in the United States has, I can safely say, never been larger. We have, even though we've gotten more RFEs and more denials in 2018, we've actually also gotten more approvals because we are just filing so many cases. So I think it's important for the nurse community, the foreign educated nurse community, to know that the demand is still here, and the American facilities really want to recruit you and to have your talents help out their patients. But that doesn't mean it's not a frustrating process. And so although it's frustrating, the need is still here, and the desire to bring you to the U.S. is very much still there.
Yeah.
And I think one thing that creates a lot of misunderstanding is that a lot of nurses and IT workers and so on will call us and say, you know, I heard the new immigration law is, you know, causing a lot of denials and so on. People should know there is no new immigration law. A lot of these RFEs and denials are just the result of misinterpretation of the law by examiners. who feel like they have the right to go after people. And if you have a good attorney who knows what the law is, you should get approved just the same way you did a couple years ago. But there may be RFEs, and there's ways to plan for avoiding those RFEs.
Absolutely. Yeah, that's a good point. I mean, the law has not changed. What has changed is the way they're looking at some of these cases. And it's really important for, because I hear a lot of attorneys are saying, oh, it's just impossible. And I know it's frustrating, but we have to also adjust to the way we're dealing with those adjudicators and show them, almost like teach them what the regulations are, which we shouldn't be doing, but it's just the reality.
Right.
Yeah. No, I agree with all of you. And I think, just to share, I have never traveled so much in my life, crisscrossing across this country over the last few weeks and months, speaking to hospitals, chief nursing officers, CEOs of hospitals, directors of nursing in nursing homes, and the demand is growing. So as you've all said, that's the good news. I think the key message, though, is that it's important to have a lawyer that really understands the space and that is a specialist in nurse recruitment, because there are a lot of nuances. So even though it's not that the laws have changed, there's just a lot of nuances that, it's important for everybody to know that, you need to have a lawyer that really knows the space. And that's also part of the reason why we wanted to do these Facebook Live sessions, because I think knowledge is power. And I think there's been a lot of misinformation, a lot of rumors about immigration. And I think it's really important and so valuable that each of you giving your time to be able to do this. Because, this week I was at a hospital in a few hospitals in Central California. And, when I was speaking to some of the nurses, I kind of like look into their eyes and you can see the frustration and the pain and the feeling of hopelessness of just trying to get here, and then the relief when they finally arrive. And that's where I know so many of you watching are experiencing that. And that's really the purpose of today, is to be able to share information. Knowledge is power. Educate yourself about the process. And I think, to my knowledge, this is the first time that we've had lawyers of this esteem, willing to share and provide information. So I just want to welcome, so I see Princess is joining us, Patrick from Riyadh, Leah has a question about the B2B, B1 visa, so we'll get to that, Leah. Richard, Bong says he's excited, Abu, Richard, Christine, Ron, Marge, Sharon, so many people joining us. Thank you everybody for joining us. We're really excited to be sharing this. And I'm going to get started with the questions. So we're going to try and have this as a discussion, but I am going to be posing different questions to different lawyers. And we're going to start off with some of the basic questions and then get into more specific. So starting off with Carl, I think, who's been in the industry for 40 years, Carl. He probably knows everything there is to know. So I think if you want to just start off with just, the basic question that we often get every day from the nurses, from nurses is, what are the visas that are applicable and not applicable for a staff nurse? Because often, people will come to me or, to our team and say, can I get an H1? Am I qualified? What about an EB2? And what is an EB3? If you can maybe run through just the visas that are applicable for a staff nurse, I think that would be very helpful.
Okay, so yeah, since my introduction has to do with my old age,
Not your old age, Carl, your experience.
I mean, back in the 70s and 80s, I actually worked for the government, and I went into private practice. And I maybe because my wife's Filipino, I don't know, but nurses seem to be something that I've done for over 40 years now. And there was an easy visa. All nurses could get something called an H1 visa. And then in 1990, the laws were changed. They took nurses out of the category. They actually put fashion models into the category. It didn't make any sense at all. Later on, I testified in front of the Senate Immigration Committee, and I said, you have to bring back a temporary visa that will apply to all nurses. And so far, they have not done that. But they created a visa back in 1990 called an H-1B visa. And it said that you had to have a job which required a 4-year college degree or equivalent. The problem is that a lot of hospitals here, a lot of nurses that are educated in the US get only 2-year degrees, and then they're hired on by healthcare facilities. So when those healthcare facilities say, oh, this nurse from the Philippines or wherever has to have a 4-year degree, they usually get denied because they say, well, look, the other nurses that you hire from America don't have 4-year degrees. So H-1Bs can be an alternative for some nurses, particularly nurses that are very educated. So if you have a nurse practitioner, that's an easy H-1B. If you have a CRNA, which is a certified registered nurse anesthetist, that's an easy H-1B. We've been successful with some of the other ones like nurse managers, but a couple things about the H-1B. One, it's a lottery every year. There's only 85,000 that can get approved and over 200,000 applications. There are some employers who are exempt from the lottery, particularly universities, but it is harder to get a nurse an H-1B than an IT worker or an engineer or an architect. So what do we do for most nurses? The only practical temporary visa right now is the TN, the Trade NAFTA visa. And the TN only works if you are a citizen of Canada or Mexico. But a lot of the nurses over the last 10 years, given the difficulties of immigrating to the US, have immigrated mostly to Canada. And boy, almost every hospital I represent, they're probably up there in Canada right now. I'm in Los Angeles, but they're in Canada. We're bringing the nurses here. But I would say in a year or two, they're going to go through all those TN nurses. So really the hospitals have to get together and lobby Congress so there's a temporary visa for nurses. Right now, we usually go straight to permanent residence, and it takes a while. So we need a temporary visa category.
Thank you, Carl. I see that Leo was asking. So I mean that that really explains. I think just to sum up, for most of the staff nurses, and a lot of nurses in Lafora are regular staff nurses. It sounds like unless you are a citizen of Canada, it's pretty much the EB3 green card that you would be going through, right?
That's exactly right.
And Carl, I wanted to add something on the TN. We had questions from people that wanted us to discuss the TN. Have you seen any complications in getting TNs in the past 6 months for Canadian nurses that are specifically Filipino educated? And the question is the same for you, Chris. Have you seen any?
Are we still on together? I don't hear anyone.
Yeah, we are.
I can hear. Maybe I can address it. So, the TN is fine. We see no problems. One very important thing is that you must have the state license if you're going to use your TN. So, for instance, if you're going to take a job in Texas, you have to have that Texas state license when you proceed to the border, the American-Canadian border or the airport. And then the second thing is you need the visa screen, which I know we're going to address in a little bit. But if you have both of those and you have an offer from an American hospital, we don't really see many problems. Of course, from time to time, the officer is maybe unfamiliar with the process, but as lawyers, we all pick up the phone and we talk to the officers and normally can get that straightened out fairly quickly.
Yeah, I think that's a good question to raise, Jacob. I'm glad that you raised that because, we bring thousands of Canadian nurses to the US. And typically, as Chris says, we really haven't seen many issues with that. As long as the nurse has got all the licensure that is required, and also that the letter for the TN is formatted into the correct TN, into the correct format, because that's sometimes where you have some issues. But we actually have a checklist for nurses going through, and I know as lawyers you have that as well. And I think it's it seems to be still pretty straightforward, as long as the nurses have the license.
And Tanya, one question we often see at our law office is if I'm Filipino or I'm Indian and I am in Canada, am I able to use the TN? And the answer comes down to whether or not you hold a Canadian passport, which is to say whether or not you're a Canadian citizen. So if you're in Canada and you are a Canadian citizen and you hold a Canadian passport, then yes, you can utilize the TN. But if you're in Canada, even if you're a licensed nurse in Canada, even if you have the US visa screen, even if you have the US state license, even if you have the letter that Tanya talks about, but you're only a landed immigrant or a Canadian green card holder, then unfortunately you cannot use the TN. So again, the question really comes down to whether or not you're a Canadian citizen or not. And we're not really talking about Mexican citizens, although because there's only a very tiny amount of Mexican nationals who typically meet the nursing standard. But theoretically, the same would be true for Mexican nationals, since Mexico is also a signatory to the NAFTA deal.
Yeah.
And Chris raises a really good point. We get asked a lot by nurses, particularly nurses from the Philippines. There are some Filipino RNs that go to Canada and they don't become RNs in Canada. They're like LPNs and so on. But if they get the nurse license of Texas or California or wherever the state is, and they were a nurse in the Philippines, they can get a TN even though they're not an RN in Canada.
Yes.
Correct. But they still have to be Canadian citizens. And that's Chris mentioned a great point, because people confuse that. They think just because they have a legal right to live in Canada, they're not qualified for a TN yet.
Correct.
Canadian citizens.
And I think it really boils down to, and I think a lot of people get confused, is that the Canadian TN is based on your citizenship, whereas the green card is based on your country of birth. So I think that's kind of the differentiator, and that can come where some of the confusion can come into it. Before we move off this topic of the different visas, though, I just wanted to raise the one question that Leo Ralph asked. What can you say about the EB2?
Okay, so the advanced practice nurses that I was talking about, the same nurses that would be able to get a TN, if they require an advanced degree, like a master's degree, a PhD, or even a bachelor's degree plus 5 years experience, then they're able to go to the EB2 category, which is for higher degree professionals, instead of EB3, which is people with bachelor's degrees or people even without university degrees, skilled and unskilled workers. And that can be an important thing. And the reason that it is important is there's 3 countries of birth. Again, we're going from, country of citizenship to country of birth. And those 3 countries are China, India, and the Philippines, where there's significant backlogs in some of these categories. Fortunately, the Philippines has not been as backlogged as China and India. A couple years ago, the waiting times were enormous. They were 7 or 8 years. Now it's down to about 1.5 years. But still, if you manage to be an EB2 nurse because you're a nurse practitioner or a CRNA, we can put you in the EB2 category, and it should take no more than 1 year to immigrate to the U.S. And by the way, that 18-month backlog, I think it's, at least in my, I don't know what you think, Chris, I'll ask you, but I think it's probably reached its low now, and it's going to start going up right now. What do you think?
Yeah, no, unfortunately, I agree with Carl. I think that is going to go from its current 18 months, maybe to 20 months or 24 months over the course of 2019. I'm hoping it doesn't get much beyond about a 2 or 3 year backlog, but I see it the same way you do, Carl.
Okay.
Yeah, I tend to agree with that. Chris, what do you think is the main reason for that? Because people always ask that. They don't understand why it's going back and forth like that.
Right. Yeah. No. So the main reason for it is just demand. There is so much demand in the U.S. for Philippine nurses, and the Philippine nurses probably use over 90% of the Philippine EB3 quota. So the U.S. government says that not more than about 8 or so thousand folks are allowed to apply under that EB3 quota before retrogression kicks in, and there is something like a 20,000 backlog in the EB3, which is why we have about an 18-month or so backlog. Now, the only one thing that we haven't really talked about here with respect to the EB2 and EB3 question, and it's really just tangential, but we do get this question, which is that physical therapists, and I realize this is a nurse form, but many of you may know physical therapists or have family members in physical therapy. Those are actually very easy to get EB2s for, because in recent years here in the US, we've moved to a DPT or a doctorate standard. So just a little aside there for any of you who are physical therapists or who know physical therapists.
And interesting that you bring up physical therapists, because one thing RNs and PTs have in common under the immigration law is under the Labor Department regulations, they're considered Schedule A shortage occupations. Those, for the last 20 years, those are the only two shortage occupations in the US. And if you're a nurse or a PT, definitely you want to use that to your advantage, because US employers, if they're bringing an engineer or an architect or a doctor or whoever, they have to go through a process where they advertise the job, and then they have to show the Labor Department that they can't find qualified Americans before they can immigrate somebody, get them a green card to the US. But the only two jobs where you never have to advertise are RNs and PTs, because they're already designated as shortage occupations. So you skip that step and it makes it faster, at least if the Philippines didn't have that backlog. It is step 2, where the employer files a petition for you. The immigration lawyers, we tend to use a lot of letters and numbers, but I'll just use a couple. So they file an I-140 with the Immigration Service. Once that I-140 gets approved, you end up getting an appointment, at the embassy on Rojas Boulevard in Manila or wherever you happen to be, and then you get a green card. That's the final step, and you come to the U.S. But that long step where employers have to advertise, they have to pay for the ads, they have to show the Labor Department they can't find Americans. That takes a long time, and some employers, not so much for nurses now because there's such a shortage, but some employers say, oh my God, I don't want to go through that process. So, sure. In a way, if you're a registered nurse or a physical therapist, you're actually one of the lucky ones, because employers will be more ready to sponsor you than they might be to sponsor an OT or somebody or a lab tech.
Yeah.
Right. And this whole process of labor certification is just so lengthy, and especially if you get an audit, you can save almost 2 years from the process by saving.
I think maybe it's delayed. I think Chris and I are hearing each other. And are you hearing us, Tanya, yeah. Or maybe it's a little delayed?
We can hear it here.
Fine.
Yeah.
Okay on my end, yeah.
Yeah.
Okay, go ahead. Go right ahead.
I was just saying that by
do people, I know we have 136 people. Any questions coming in?
We've got a lot of questions.
Yeah.
And I'm watching the clock because the questions are coming fast and furious.
Okay. We can do a second one, but go ahead with the question.
Okay. So we've covered a lot of, questions.
I know we have 136 people. Any questions coming in?
We've got a lot of questions. Yeah. And I'm watching the clock because the questions are coming fast and furious.
Okay.
We seem to be having a delay.
But go ahead with the question.
Fine.
Okay. So we've covered a lot of, questions.
I know we have 100.
I think we seem to have had a little bit of a technical little glitch there.
It seems we're working fine. I think we dropped.
It looks like the words were repeated that we already said.
Yeah.
I do not see Jacob or Chris. I hope you see them.
Yeah. I see everybody. Can you see us, Carl?
Chris.
Okay. Let's move on to the next question. I think I'm going to move to Chris.
We are broadcasting from different cities in the U.S. as well. So, Thank God we are still live.
Still live, yay! Grateful for the technology, and thank you to Jacob for administering everything. So moving on to the next question, I think something that's coming up more and more from a lot of the nurses and as I said, I'm going to direct this one to Chris, is on September 11th, the USCIS implemented a new memo. Can you tell us a little bit more about what this entails and what you think the implications are for the RNs?
Yeah, so this memo did receive quite a bit of buzz in social media and in blogs and in various other places. The good news is it ultimately hasn't resulted in really any material difference here after almost 3 months. But what the memo essentially said is that the USCIS is now allowed to, instead of issuing an RFE, just immediately issue a denial to your case. Again, the good news is the reality is we're not seeing that. We are still seeing the RFEs. Now, the RFE rate is sky high, certainly compared to history. You know, the first 10 years I was doing this, from 1998 to 2008, we would get an RFE every, 20, 30, 40 cases. It was very rare. Now we seem to get them on every other case, or even 2 out of every 3 cases. But the good news is, with respect to the September 11th memo, which does give USCIS officers the ability to go to a straight denial instead of issuing an RFE, at least at our office, we haven't seen any cases like that. I don't know if either Jacob or Carl have seen any uptick in that area.
No, I
haven't seen any.
We haven't seen any. But what we have done, we have been preparing for the possibility that we will get some of those. So we're starting to prepare our cases as complete as possible, anticipating that if we don't, we may get an RFE. So it's just a little bit of be more prepared. But I haven't seen any changes. I agree.
Well, that's certainly good news that there haven't been changes. But I think, Jacob, you bring up a good point of being just significantly more prepared. Mm-hmm. Can you maybe share some of, or just open to the panel, can you maybe share some of the ways that you have started to become more prepared?
Right. So, for example, if we submit I-140s, we want to make sure we have all the credential evaluations ready. We don't have any. We don't leave any educational documents that need to be prepared. Any materials from any documents from the home country, any ID documents that clearly are missing. If we say, oh, yeah, we can file it and we get an RFE, any documents from the employer proving ability to pay or anything like that. We just try to give as many things as possible in the early stages of the filing, and we're not relying on our fees because we assume we may not get them. So it's just kind of like a different state of mind. But obviously, we always try to do the best we can, but we always have to be mindful. If we don't, it will result in a denial. So and specifically, I see it in B cases where we try to change status. Those have been we've seen a few denials that came without RFEs. And this is the only area that I've seen that we got some denials where people were not 100% ready to show that they are qualified for a change of status. I don't know about you guys, but this is the only area I've seen a few denials without RFEs. The B1 extensions and change of status.
Chris and Carl, any other areas that you are looking at to get the cases additional documentation to be a little bit more prepared after this memo?
Well, Tanya, I know you and I have talked about this in the past, and it's about, again, with officers that are not informed. You told me that you know of some hospitals that have gotten denials of the I-140 that I mentioned because the nurse didn't have the visa screen at the time. Now, from a legal standpoint, you only have to have the visa screen when you're applying for the green card, not the I-140. And thank God, I mean, I haven't had an I-140 denied for that. But some of the hospitals that I represent, they won't even submit an I-140 unless the nurse has the visa screen. Number one, they're probably afraid of those denials. Number two, some nurses, they should, join your IELTS group. Some nurses just have problems passing the English test, so they don't want to put out the money to sponsor a nurse that may never pass the English test. So there's two, practical considerations why maybe it's a good idea to have the visa screen when you file the I-140. But frankly, we are still filing I-140s even if the visa screen isn't there, if our employers are okay with it, and we're still getting them approved. But it's not, from what I've heard from you and from some of the hospitals, It's not universal. So if you filed an I-140 without a visa screen and they denied it for that reason, then the lawyer would have to have a motion to reconsider the denial and then get the I-140 approved. So it would just introduce another step into the procedure.
Right.
Chris or Jacob, any comments on that?
Yeah, I agree with Carl. I think it's really a question of what the hospital agrees and what we can agree with them. But I haven't seen any denials when filing an I-140 without a visa screen. But I know some are, because of the recent concerns, people are more diligent to do that. So it really depends on who you're working with. Some of them are now willing to even sign it without having the visa screen. So.
Chris?
Yeah, I mean, and if you're the hospital, as Carl and Jacob both said, it does make a lot of sense for the hospital to have some confidence that you are going to pass your IELTS. And so I'll also suggest that you as the nurse want to take some sort of an IELTS training course. I know Tanya's is about as good as any that I've seen. But, you know, I think what we're seeing in the RFE and the NOID and the denial area, and this is something Carl touched on, is really more a question of the USCIS officers not being very well trained, more than an issue with the nurse's background and her credentials, or even the facility's ability to sponsor a nurse. So the question is really one of how can USCIS get their officers better trained than, frankly, anything that you as the nurse can do. As you as the nurse, you want to focus on passing your NCLEX, passing your IELTS, getting that visa screen, and getting a good solid job offer from a good reputable company. And after that, you know, it's a pretty straightforward process.
Yeah.
And another thing I want to add to, that's a good point, Chris, that for the first time, it's been a little over a year, but on October, this is not directly related to the memo, but on October 1st, 2017, they started for the first time in over 20 years requiring all the employment-based applicants for green cards who are adjusting their status to be interviewed in the U.S. And, you know, while I don't have any problems with that, the Immigration Service, my old employer, they definitely have a problem with it, because all these applications have been for 20 years handled by the service centers. And now it goes to the district offices where, you know, where our attorneys appear every day. And in the district offices, probably the officers just don't have a whole lot of training in these different employment categories. Particularly nurses tends to be very specific. And so you go for an interview and they'll ask things, you know, they'll ask for things that are not really required. They will bring up issues that, you know, I haven't seen in 40 years brought up. You know, they'll say, let's just use an example. We have a nurse who actually came to the U.S. and went to nursing school, and she got her license in the U.S. And by the way, for reasons that I won't even go into, she needs a visa screen to show that her diploma from a U.S. school is equivalent to a U.S. nurse. It's like, doesn't make any sense, but you know, that's the way it goes. But in addition to that, things have been tougher under this particular administration, and the officers will often go back 10, 15 years and say, oh, well, when you were going to UCLA or University of Maryland or wherever it was, we noticed in this quarter that you had dropped a class. And, you know, for an F1 student, you have to be full-time student. Or the nurse will say something like, oh, you know, when I was in college, I worked at a restaurant and I didn't have a work permit or something like that. And they'll go back years and years and years as an excuse to deny an application. So you have to be 100% prepared when you walk into that interview with that nurse. The lawyer has to be prepared that this could be a question that's going to come up. You know, I would say the denial rate because of these things is quite a bit higher than it used to be a year and a half ago.
Yeah, I think that's an important point, Carl, because as you said, I mean, you've been doing this for 40 years and you're seeing things that you haven't seen before. And just to go back to that visa screen issue, I mean, it wasn't that there were denials on hospital cases, it's that they were RFEing the visa screen, which, I mean, I've been doing this for a long time as well, and I've never seen that before.
Right.
You know, where they were asking for the visa screen, and you know, that's where it's just highly recommended maybe that the nurses have the visa screen and obviously pass the IELTS before the I-140 is filed. It's obviously not technically essential, but it is highly recommended because, you know, you have a certain number of days for an RFE, for a request for further evidence. And if you haven't passed the IELTS, we all know, everybody on this forum knows how stressful it can be to pass the IELTS. And if you have a deadline to pass the IELTS, get the visa screen, I mean, that adds a whole nother layer of stress to this already stressful process.
Right. So, yeah, ideally, if the nurse has the IELTS, she has the visa screen, and then the I-140 is filed, it should go very smooth. But legally, as an attorney, we know they don't have to have it, and if they have an attorney who's knowledgeable, we can fight back and forth with immigration. But if you're a nurse who doesn't want to have your attorney fight back and forth, which I totally understand that.
Mm-hmm.
If you get the visa screen beforehand, it's going to be a smoother road.
I guess that the idea is to just make it easier for them as much.
Exactly. We want it easier. We want a smoother road. So, and before we get to the questions, and we are getting so many questions, I'm worried we're not going to be able to get to everybody. But I see that, where was it? Maybell asked, why is the movements of the Philippine priority date is quite slow compared to before? So, Jacob, I want to address this one to you. If you can maybe just talk a little bit more detail about the visa bulletin, why Philippines is slow, why we anticipate it might actually get slower. I think, that's an important topic to cover.
Right. So I think, again, it's all about, like Chris said, supply and demand. The more demand there is, the less they're able to issue visas, and they allocate them based on that, on quotas. So, Philippines, China, and India were the #1 countries that use visas on the employment side. So that's kind of the main reason why we have a shortage right now, and we're hoping that in the next year and a half, we'll see even a longer wait time, but we hope it's not going to be too long. But it's all because of the supply and demand, and then every year the government will look at how many visa quotas they have, and they'll release. And it's the same for any other employment category, but specifically in this particular one because it's such a high demand from the Philippines to come here as nurses.
Tanya, 2 quick points, I think, as long as we're talking about visa bulletins, that I think are important for the viewers to understand. The first is the visa bulletin goes by country of birth. I think we touched on it before, but it bears worth repeating. And so if you are born in the Philippines, but you become, let's say, a UK citizen, unfortunately, you still go under the Philippine quota in spite of the fact that you then hold the UK passport. This is particularly problematic for our Indian nurses who have a 10+ year backlog, as opposed to, if they were born in the UK, they might only have they basically have no backlog, and so it's just the year or so that it takes the U.S. government to process the case. So that's one point I think that's important. Keep in mind, it's a country of birth system. The second one, which is rare, but I think it's important for everyone to know, I'm seeing a lot of people who are commenting who say that they're from some of the Middle Eastern countries like UAE. I'm seeing other UK and Canada folks, that if you marry someone who was born in another country, there is a rule called cross-chargeability, which allows us, even though you're the nurse, if you were the spouse, and let's say your spouse was born in Canada, we are actually allowed to petition your case under your spouse's country of birth. And so the Canadian number, for instance, or the UK visa bulletin number is just much more favorable. All of the attorneys here, I'm sure Jacob's team and Carl's team do it, and our team do it. So one of the first things we'll look for when we get the spouse's documents as well is we will point that out and make sure that you're processed under the proper queue. So anyway, that's a key point. Again, it's called cross-chargeability, and it means if you marry someone who was born in a different country than you, we are allowed as lawyers to choose the faster country to petition your case under.
Excellent. That's a really good loophole for people that are stuck in this wait, especially from India and China and the Philippines.
Yeah. And it's a little known fact. Not everybody realizes that. We actually had a case like that recently. It was a nurse who was going to come to the US before, she was Filipino born, before the retrogression, instead went to the UK. When she was in the UK, she met a British man. So he's obviously a UK citizen, and we've just done her case with cross-chargeability. So, and she wasn't, didn't even realize that that was even a possibility. And obviously that cuts down the timelines enormously. Mm-hmm. So, okay, so I think we only have a few minutes left. So I see we have questions from, oh my goodness, there are so many people commenting. So this is really exciting. We have Clarissa, Luba, Christian, Dee, Dewey, Angelica, Princess, Ange, Leo, Japoy, lots and lots of questions, lots of people commenting into the chat box. So thank you so much for all the questions. And I'm going to ask now just a few questions from some of the people who have posted. The first one is a question that we got from Bong. He actually posted before we even started, so I'm going to give Bong the first opportunity to get his question answered. His question is, and I'll read that: we have a tourist visa. Can we enter the US first and process the papers and work there? I'll bring my family along, or will it be better to wait in the Philippines?
I would say,
and I, you know what, I just realized that. Because for me, I don't know, I think you guys are able to see Jacob, but I cannot see him or hear him here. So if I've talked over you a couple times, Jacob, I really apologize. I just saw, Chris and Tanya like intently listening, and I thought they hadn't heard the sound, and it was probably you talking, and I chimed in. So I really apologize if that happened. When you come on a tourist visa, you are supposed to have no intent to remain in the United States. There are exceptions to this. I mean, people come on a tourist visa and then 5 months later marry an American citizen or something like that, and there's no penalty for that. But certainly, if somebody comes on a tourist visa and then in the first 90 days applies for a green card, that can be seen as fraud. So you definitely do not want to do that. An employer could petition for you for the I-140 while you're here on a tourist visa. But like I said, if it happens in the first 90 days, please go and have the green card interview at the embassy in your country, and do not overstay your visa, because if you overstay by over 180 days, there's penalties, and you may not be able to come back to the U.S. for either 3 or 10 years. So, definitely talk to your lawyer about it, because I should bring up, I probably a very small minority of our nurses might be students in the U.S., but there were new regulations that came out on August 9th about unlawful presence for students. And I think, I won't go into it now, nobody's really interested in it, but come February 9th, which will be 180 days from August 9th, I think this is going to be a major issue for a lot of students in the United States who want to get green cards. So, make sure you talk to a lawyer, and don't just come in on a tourist visa expecting to switch and get a green card.
Yeah, and I think the biggest misconception is people think they can come on a tourist visa, apply for the green card. In this case, it's an I-140, but that won't allow them to be legal here for the duration of their the wait time until their turn. So for the next 2 years, they can't be here, and that's the biggest misconception. And most people realize it after they arrive here as tourists.
Yeah, just to put a final point, because I know, Tanya, we're running low on time. So certainly everything Jacob and Carl said is correct. On the broadest point, I think, there was a long time when that B visa entry and eventual adjustment of status was actually pretty common here in the U.S. And the reality is that it no longer is a permissible approach. It was frankly probably only questionably permissible, but the USCIS didn't really seem to enforce it. As you know, if you're taking nothing out of this Facebook Live session today, take this. The fact that you have an older cousin or brother or sister who may have gone through this process or any U.S. immigration process a few years ago in one path, and they're telling you, oh, I did it, it will be fine for you. Unfortunately, that's just bad advice you're getting. The immigration world has really changed in the last year or two, and so it's exceptionally important that you have a good immigration attorney keeping an eye on your case, and it's exceptionally important that you have a good employer who's keeping an eye on your case, because really the immigration rules have really changed, not so much in the text of the law, but in the application of the law.
Yeah, I think that's really good advice, because you know, as I said in the beginning, there's a lot of misinformation, a lot of rumors, things have changed, and it's really, really important that you know, you educate yourself and that you make sure that you don't do anything that's going to jeopardize you in the future. So I think it's a good question that, you know, that Bong asked that question, because you know, I think you can hear from all three lawyers that's really a cautionary tale. And it's really important to be very, very careful about doing, you know, following the law and making sure that it's all about intention. If you come on a visitor's visa, then your intention is to visit. It's not for anything other than that. I think we have time for one more quick question. So we had a question from Ricardo, who asked, what if the principal applicant, the green card holder, is not yet started to work due to a licensing endorsement? Will there be any issue if they are outside the country for 5 months? I don't know who wants to take that question. So in other words, I think what Ricardo is trying to ask is that if the person has got their visa but doesn't enter the country, I believe it's 6 months, but if you want to just clarify.
Once they get their immigrant visa for a green card, yeah, they do have 6 months to enter the U.S. So if they stay out for a few months, as long as the employer's okay with that, it shouldn't affect their ability to get a green card. But you're just to clarify, so people know, you're not actually a green card holder, even though the U.S. Embassy in your country has approved your immigrant visa. You have to actually travel to somewhere in the United States, and at the airport, there's we call it the Customs and Border Protection. There'll be an officer. They'll send you to a room which is called secondary inspection, and they'll go through the paperwork that the embassy approved, and only when they put the stamp in your passport are you a green card holder. The actual plastic card will be mailed to you weeks or months later, but you know, some people think, oh, I got approved at the embassy, I'm a green card holder. Not until you enter the U.S. But Ricardo's or Tanya, you're right about that. It is 180 days.
And Gabrielle just asked, it's 6 months from the medical exam. Is it 6 months from the medical exam, or is it from the consulate?
From when they approve the visa, because you could have a medical, you could come and have your interview. They could ask you for some more paperwork, and it could be 2 months down the line. But the 180 days aren't running until they approve the visa application.
Right.
So the key thing is to look at that visa that's issued by the passport, because we will sometimes see them issued for less than 180 days. And what we've found 9 times out of 10, it makes more sense to just enter the United States before that visa expires, rather than go back to the embassy and try and fight for, you know, if they gave you less. We have seen some instances where if the passport isn't valid for a lengthy enough time, they'll give you less than 180 days. So I think the most prudent thing is just, the visa is very straightforward. It'll have an expiration date. That's when you should enter by.
And that's been the main reason why we've seen less than 6 months is the passport expiration date. And we always tell them, just go in the U.S., go for a week, get it done, and then, you know, take care of your stuff.
Okay. All right, good. Well, I can't believe it. We are out of time. Time flies when you're having fun. So many good questions from everybody. I just want to thank the Lafora team I know, Chris, you're a moderator in LaFora, and I think that just being able to share this information is just so valuable and will be of service to so many people, and that's really just the intention. We were looking yesterday at the statistics from the American Nurse Association, and it said, and they say that the US will need more than 1 million nurses by 2022. And considering that we are almost at the end of this year, that is almost, that's around the corner. So obviously, many of the hospitals and nursing homes are going to continue to recruit American nurses. But there is a huge opportunity for internationally educated nurses. And the timing is really good. So for those of you who have passed the NCLEX and are working on your IELTS or passed the IELTS, there's really no better time. So to the panelists, any last thoughts? Any last bit of information, pearls of wisdom?
I would say that, like you said, this is a great time to pursue the nursing career right now and try to come to the US. There's a lot of opportunities. And while the government is making it difficult for everybody, I think at the end of the day, those that are really qualified will make it. And, for us, it's just, more hours at the office, right?
Chris or Carl, any last thoughts?
Go ahead, Chris.
Yeah, so no, I really just want to thank Tanya and the team and Jacob for setting all this up. This has been a lot of fun. I got cut off there for a minute, so I posted my email address in the comments. If you have any questions, please just go ahead and send us an email. We'll be happy to try and answer them. And good luck to everybody. This is America's still a wonderful country, in spite of some of the headaches that we've described this morning. And I think we would greatly be enriched by you guys coming here.
Perfect.
I think we lost Carl. I'm not sure. So I think that brings us to a close. Thank you again, everybody, for attending and for the. There, Carl. Do you have any last thoughts?
Well, same thing. I think if you take a look at our the three of our websites, so mine is just my last name, Schusterman.com, but we have a nurse immigration guide and all these things about licensing, visa screen, finding jobs. All of that is covered on the site. So take a look at one of our sites or all of our sites, and it will help educate you. Great thing about the internet is it's worldwide, so no matter where you are, you have access to the information on our websites.
Excellent.
While we've been talking, I've just been getting a few messages through asking us if we're going to be doing this again. So just to share with everybody, we have agreed that we will be doing this. I think we said once a month, right?
That would be great.
You're going to see us again. So keep the questions coming. Please share this with every one of your colleagues and friends. The most important thing is that we want you to, the American dream is still very much alive, and it's really important to educate yourself about the immigration process. So keep the questions coming, and we will see you next time.
Thank you, guys.
Thank you, everybody.
Okay.